Erin Acker is one of my favorite people in the world. She's a partner at the maritime aviation law firm Moore & Co., located in Miami, Florida, where she's been serving clients for more than 19 years since they opened their door in 2004. And I get to work with her because she's president of the International Super Yacht Society, and as I've been on their board for a long time as well. Listen to this experience. She spent several years as professional crew member on board several sailing yachts, transiting the Panama and the Suez Canal and far beyond that. She graduated from the Maine Maritime Academy, and she's well experienced, and she's a great representative for our industry. Erin?
Is everybody awake after that fabulous lunch? Okay, I'm here today with my colleague Gabriel Pla. We're just going to do a quick presentation for you about e-signatures and e-notarizations. So essentially, Gabriel will give you the lion's share of the presentation. It's a very long presentation that we're going to kind of go through quickly. But we thought about what we were going to do with this presentation, and we were like, well, we did the research, so we're going to keep it in the presentation, and we will disseminate it to anybody who wants a copy. Instead of cutting it out and making it very short, we kept it long, but we're gonna go through it very quickly. So we'll keep within our time slot. So I'm gonna turn it over to Gabriel, and then I will wrap up some comments after he finishes his first part. So Gabriel is an associate here with me at Moore & Company. So Gabriel?
Good afternoon, everyone, and thank you, Erin, for that warm introduction. So today, I'm just going to go do a quick overview of, excuse me, I'm going to do a quick overview of electronic signatures and electronic notarizations because there's been recent developments in that might be beneficial for you to know in the yacht industry. So with that being said, I'll go ahead and get started. So at the outset, it's important to point out that there are two overarching federal regulations that govern the validity and enforceability of electronic signatures and electronic notarizations. And the first is the Electronic Signatures in Global and National Commerce Act, otherwise known as e-sign. And the second is the Uniform Electronic Transactions Act. Now, the e-sign Act, which is codified in 15 USC Section 96, it's essentially a federal statute that compels all 50 states to accept as valid and enforceable electronic signatures. And I'll go into that in a little bit more detail, but that's essentially what it is. Now, the Uniform Electronic Transactions Act, on the other hand, otherwise known as UETA, is a set of guidelines or proposals that have been put forth by the Uniform Law Commission. And they're basically just a set of recommendations that are given to the states to help them and guide them when it comes to enacting their legislation that recognizes as legal electronic signatures and electronic notarizations. And pretty much all states have adopted the UETA word for word, including DC and Puerto Rico, with one exception, and that would be New York. And I'll get into that in a little bit later. But what you'll notice is, and as you'll notice when I sort of breeze through some of the other states, is that the states pretty much adopt the same language from the UETA, word for word, the same requirements and the same exceptions across the board. So that's something helpful to keep in mind that sort of helps you understand all of this a little bit quicker. Now, at their core, the e-sign and the UETA have 5 main requirements that need to be met in order for electronic signatures, and by extension, electronic notarizations, can be deemed valid and enforceable. First, there's got to be an intent to sign. So all the parties to the transaction got to have an intent to do the signature and a notarization electronically. Second, all the parties got to consent to do this business electronically. Third, there's got to be sufficient attribution. Fourth, there's got to be association of signature with the record. And then fifth, there's got to be sufficient technological capabilities to store these records and these notarizations electronically. Now, as I said, there's a number of exceptions to electronic notarizations and electronic signatures that you can't use them on, different types of documents that you can't use them on. And this is all put forth by the UETA, which, as I mentioned, was pretty much adopted by all the states except New York. And those documents are, anything, wills, codicils, or trusts, any documents related to family law matters, all UCC transactions other than those pertaining to sales and leases, different types of notices such as for default, acceleration, repossession, foreclosure, those types of notices, you can't use electronic signatures or electronic notarizations. And there's a number of other exceptions. I won't go through all of them, but you'll see that pretty much all the states pretty much adopt them word for word. So with that being said, I'm going to do a brief overview of the states in terms of electronic signatures and electronic notarizations. And I'll start off with Florida, which is perhaps the most applicable and relevant state to us. So in Florida, it's important to know that electronic signatures are perfectly valid and enforceable. Florida, like almost all other states, adopted the Uniform Electronic Transactions Act. So it has the same requirements and the same exceptions across the board. And the legality of electronic signatures is codified through Florida Statute 66850. And that right there is an excerpt from the statute, the applicable language. I won't read through it, but just for reference, and we'll be able to hand out copies of this after the presentation, but it's Florida Statute 66850, subsection 7. And essentially, it just provides that electronic signatures are perfectly legal and acceptable in Florida. Moving on to electronic notarizations in Florida. So in Florida, electronic notarizations are perfectly valid and enforceable as well. This is recognized through Florida Statute 117265. Now, when it comes to these electronic notarizations, there's several requirements. The main one being that the electronic notary, so this is all done remotely. It's kind of like you're on a Zoom call and you have the notary on one end and then you have the signatories and the witnesses on the other end. So essentially, one of the central requirements in Florida is that the notary has to be physically located in Florida. However, the signatories or the witnesses, they can be virtually anywhere in the world. Another central requirement that you have to keep in mind that the notaries have to make sure they're employing for this to be valid is that they're using state-approved audio-visual communication technology. And that's provided in various means. There's typically a software application that you buy from that a notary, an online notary would buy from a vendor in order to perform that. Another requirement that's really important to note is that the notarization session has to be recorded by the notary, so that's important to keep in mind as well. And then very important as well is that the notary authenticate who the principal is through getting their government issued ID and other sort of sensitive personal information that they're able to use to verify their identity. And then lastly, when you're working with some of these online notaries, in terms of ensuring that their commission is up to date, it's important to note that their online commission is separate from their traditional notary commission. So they run concurrently together, and when the traditional notary commission expires, the electronic one expires as well. So they basically run together. So it's important for them to keep that in mind when you're working with an online notary, to make sure that their commission is up to date and you're working with a notary who has a valid commission. So moving on to some of the other states, I'm just going to kind of breeze through these just to give a general overview. But in Massachusetts, Electronic signatures are perfectly valid and enforceable there as well. They have their own statutes recognizing that. They, like almost all other states, adopted the Uniform Electronic Transactions Act. In Massachusetts, electronic notarizations are valid, but not until just a few weeks from now. Starting January 1st, 2024, there was some legislation that they passed that basically recognized as legal electronic notarizations, but beginning next year. So in Georgia, as in most other states, electronic signatures are perfectly valid and enforceable. However, in Georgia, electronic notarizations are not valid and enforceable. So if you're in Georgia and you're doing a transaction in Georgia, you have to go through the traditional, wet ink approach, in person, old school kind of way. And so that's important to keep in mind. And there's also no indication whatsoever that the Georgia legislature has any intent to pass a bill or some sort of, to pass a bill recognizing electronic notarizations as valid. So there's no really any movement there in Georgia. In Virginia, electronic signatures are valid and enforceable. They've also adopted the UETA. And in Virginia, electronic notarizations are valid and enforceable as well. Texas, same thing. Electronic signatures are valid there, as are electronic notarizations, and they have their own statutes to recognize that. Moving on to Louisiana, same thing. Electronic signatures are perfectly valid and enforceable there as well. As are electronic notarizations. So one thing that you'll notice is if you're doing a transaction in a particular state, you want to make sure that you're looking at the requirements for electronic notarizations because they do vary slightly by state. Every state has their own statutory code that kind of lays out what is required, what needs to be shown, what needs to be proven, and so that's important to keep in mind. But in Louisiana, electronic notarizations are valid as well. So moving on to California. California, electronic signatures are valid and enforceable there as well. They've adopted the UETA. However, in California, electronic notarizations are not recognized. They're not legal in California, at least right now, because just a few months ago in September, Governor Gavin Newsom signed a law that would legalize electronic notarizations either by January 1st, 2030, or unless and until, before that point, the California Secretary of State updates the technological capabilities in the state to be able to meet the demands of doing electronic notarizations. So moving on to the state of Washington. So in Washington, electronic signatures are valid. They have their own statutory code to reflect that as well. And similarly, electronic notarizations are perfectly valid and enforceable in Washington as well. And then lastly, New York. As I mentioned, New York has not adopted the Uniform Electronic Transactions Act. However, nonetheless, rest assured, in New York, electronic signatures are perfectly valid and enforceable because they just passed their own laws to basically recognize them as legal. I won't read through the statute's language, but essentially, those are the citations right there. And then lastly, in New York, electronic notarizations are valid and enforceable as well, so that's great to keep in mind as well. And with that, I'll turn it over to my colleague, Aaron Acker.
So that's a lot of information, I know. But the reason we put it all in there is to kind of show you the distinction that there are some states that still don't recognize e-notarizations, that there are different requirements state by state. But when you're doing these transactions, you kind of wonder, I know as lawyers we all wonder about, like, can we use this? Because it's convenient and people like the idea. But here's a further some further information when you're kind of trying to analyze whether or not you can use these electronic signatures and notarizations in your transactions in the documents. So we kind of looked at a few of the flag states as well. The first one is the Coast Guard. So with respect to the Coast Guard, they basically adopted, over the COVID-19 pandemic, they made a decision to essentially accept all e-signatures and e-notarization. So if you have a boat that you want to document with the Coast Guard, they will accept those documents, provided that they're, executed legally in the state where they're coming from. But with respect to the Cayman Islands Registry, it's a little bit of a different story. So the Cayman Islands Registry, and I know a lot of you in this room, we all work with Cayman Islands quite regularly. It's probably one of the, it's one of the larger flag states, the largest. But they have a different take on it. They will accept e-signatures on certain documents and not on others. So they'll accept the e-signatures on their vessel registration forms, but with an exception with where you have to do the authorized person form. They will not accept an e-signature on that form. They won't accept e-signatures on bills of sale, builder certificates, mortgages, or other documents that need notarization. So that causes a little bit of a problem, a question mark. And the Marshall Islands Registry takes a different approach. They're a little bit more modern in their approach with this, with e-signatures and e-notarization. So essentially, as long as you follow their rules for e-signatures and e-notarizations, they will accept the documents. You have to demonstrate that the document's been e-signed on what they call a trusted provider, such as Adobe Acrobat, Dropbox, or some other platform that has the required security and verification. And they also accept the e-notarizations as well. And then we also looked at the Bahamas, so we thought, let's throw in one more. So the Bahamas Maritime Authority, I know a lot of people in this room also work with the Bahamas Maritime Authority, and they have similar kind of restrictions as does the Cayman Islands. And so they basically, what their position is that they will accept e-signatures are valid on certain documents, not on all documents. So, so things that they will not accept e-signatures on include like bills of sale, again, builder certificates, mortgages, and other documents requiring notarization. And they do not recognize e-notarizations at all. So, so we thought we'd just give you all this information to kind of, we're happy to provide you with our research and the document. We can give you the PowerPoint presentation so you can use that as a kind of just as a guide. But we just want to, essentially give you when you're doing these transactions, the goal behind ultimately this presentation was to say be careful, because yes, it's valid and e-signatures are valid and enforceable in Florida, and e-notary documents, e-notarized documents are valid and enforceable in Florida as well, but there are other states that don't necessarily recognize that, and there are other flag states that you're going to be working with that don't necessarily recognize that. So it's important to kind of plan before you go to a closing and just say, we're going to do all e-notary and e-signed documents, because ultimately you may limit your client's ability to register the boat in a flag state that they prefer, or maybe later down the line they want to change flag state. So while now we're moving towards the goal of e-notaries and e-signed documents, and that's moving along, and there's a lot more, it's a lot more common these days, it's still not complete. So our message is to be cautious and plan and look at these situations carefully before you accept these documents as being something that you can use for everything. So I think we have some time to take some questions, but that's kind of the end of the presentation. I know that we went through it very quickly, but we only have 15 minutes, so we're kind of breezing through this fast. So,
questions? Aaron and Gabriel, thank you very much.
Not a single one. Thank you.